Yeah, I want to state from the onset that Korir worked with me at the county in Bomet as our county actually. I know him as such, we've worked with him. I don't know whether CJ, I'm therefore conflicted.
Well, the decision to recuse is usually personal, especially if a member feels conflicted. If you do not feel conflicted, the disclosure is enough.
Yeah, we just worked with him. He was our good officer. I have no conflicting issues.
Very well. That is noted. Thank you very much, commissioners. Mr. Korir, the commissioners will be engaging you on your application that you have made for the position of the judge of the High Court. Before we delve into the interview, you can confirm to us your county and your ethnicity.
I come from the county of Bomet, and I'm a Kipsigis.
Thank you very much. Commissioner Masharia will take us from there.
All right, a few questions. The first one relates to your CV. I can see you've straddled between a bit of practice, but also largely having worked in organizations as an in-house counsel.
Yes, Your Honor.
Now, could you tell us, as a commission, the main reason why you are seeking to join the judiciary at this stage?
Okay. Thank you, my lord. I'm true. I've worked. First, I started with the Capital Markets Authority, 1995 to 1998. Between 1998 and 2010, I worked with James Finlay Kenya Limited, some multinational tea company in Kericho. Thereafter, I came back to private practice. 2016 and to 2017, I worked with the county government of Bomet. At this stage in time, I believe that with the number of years I've been in private practice, and with the first knowledge that I have in management and gained both in the private sector and the public sector, I believe that I have what it takes to be the judge at this point in time.
Now, you know, the position you're seeking is not a management one. It's one where you're required to run the course of determining disputes, and that requires experience, and you're competing against fairly experienced people. Now, could you demonstrate to the commission what specific experience you have, and demonstrate by giving examples of matters that you've handled where you think that they are of jurisprudential value, or any other skills that you've acquired that you think, by giving very specific examples, that you are judge ready?
Thank you. Thank you, Commissioner. I think I believe the work of a judge would actually require both the administrative skills, the management skills, and the vast legal knowledge of an individual to be able to dispense with the work in the office of the judge. As I have indicated, I have that vast experience in management gained from my many years in the corporate world. On the side of practice and the experience that I have been able, in my own law firm in Kericho, been able to handle quite a good number of cases. I've actually successfully prosecuted them. Of course, in practice, there is always there are always those cases that you will win, and there are those cases that you will lose. One case that comes to mind involved an estate of a very senior person in this country, where I prosecuted with one of my colleagues in Kisumu. It was a succession matter, and we successfully prosecuted it. It went to the Court of Appeal, and that is when our client gave up, but we were still ready to pursue it to the end. I think there was some family concessions, and our client was sucked into the family issues. Ultimately, our client actually succeeded. At the moment, I'm also handling a very sensitive matter on historical injustice involving some families in Kericho, where they lost a lot of land to one of the multinational tea companies in Kericho. And looking at all those cases that I've handled, and being in court since 2010 when I resigned from my job in Finlays, I believe that I have the ability, I have the knowledge, I have the experience to be able to sit in the office of the judge and dispense the duties in the office of the judge.
Okay, so my final question, it's a constitutional imperative for us when it comes to picking people from who are not JOs.
Yes.
You have to demonstrate that you are distinguished. This is not a discretion on our part. We must be able to show that amongst the ones who have competed, that you are indeed distinguished. So what makes you distinguished? And you remember, distinguished means that in comparison with the others, you are way, way above, so that a reasonable person looking at all the circumstances and looking at the interviews, these are interviews that are live, they can be able to say that among the applicants, as we chose Eric Ngeno, he is indeed distinguished. So what is that?
I have the integrity that is required by the office of the judge. I'm very sure that I can be accountable. I also possess the academic background that I've gone through. I have an LLM, and I think my first research experience and the past engagements in the county government and in the capital markets when I started as a legal officer, I'm very sure I have that distinction to be able to sit in the office of the judge and be able to dispense the duties of the judge. If allowed, I can be able to demonstrate even the work that I was doing in the multinational companies. A lot of it involved a lot of legal work, and it spread across a wide spectrum of legal claims from the insurances, community issues, and so many other issues. And I think I have the distinction and I have the experience to really sit in this office. And at the end of this session, my ladies and my lords, when you will be able to score all the other applicants, I think I'll also be able to be scored quite well.
Thank you, my lady. Good morning once again.
Good morning, madam.
You said you practiced, huh?
Yes.
Yes, in the area of civil law, I've seen in your CV.
Yes.
You've handled accident cases?
At the moment, I handle a lot of accident cases.
Okay.
I work for a good number of insurance companies.
Mm-hmm.
Yeah, but as a defense counsel.
Okay.
My experience with accident cases was informed largely when I was in James Finlay's. Mm-hmm. When I joined James Finlay's, they had more than 7,000 matters. Yes,
I got that in introductory.
And accident cases are actually the defense.
Okay. So now in fatal claims.
Yes.
Under the Fatal Accidents Act, what kind of remedy is offered? Let me leave it at that so that I don't preempt the answer. What kind of remedy is offered in a fatal accident?
In most cases, they are general damages.
Yes. So,
and
under what head?
And special damages in some cases where they are demonstrable.
Okay. Under what head are the general damages payable under the Fatal Accidents Act? What do we call that category of general damages? Okay, in a fatal accident,
yes.
Generally, let me not limit it to any act. What are the categories of damages, the heads of damages that are awarded usually?
the general heads or damages that are payable on fatal accidents.
Yes.
We'll have loss of earnings if he was an employee. We also have pain and loss. We also
Pain and suffering.
and suffering. Yes. We also, if the deceased was an employee, we also look at the lost opportunity to
If
his
he had
family,
dependents, okay,
to his family and other dependents.
So which of those falls under the Fatal Accidents Act?
The pain and suffering.
Under the Fatal Accidents Act?
I think I need to check that.
Okay, let's leave that.
Yes.
How do we calculate loss of dependency?
It is usually the number of the number of remaining years by the earnings of the individual. Yeah. At the time of the accident, and if that person was just a general worker, we always go to the general order and look at the general order and work from the general the wages general, that as a basis of calculation.
So you say if he doesn't have a salary or if he doesn't have a payslip?
If he doesn't have a payslip, if he's not employed and he doesn't
So
have
what
a
if he
payslip.
had no job?
But that is one of the scenarios again that we'll use. Look back to the general order and work on it. I've worked on it successfully, and
If he has no job at all?
If he has no job.
Okay.
Because at the end of the day, that person was being depended on by someone, and there is a loss to that family, especially if the family demonstrates that he was a breadwinner. At the end of the day, there must be a basis.
Okay,
that
just
you can
hear
work
me
on.
out. What I asked, he has no job.
Yes.
Okay, thank you. Thank you, my lady.
Thank you, Mr. Korir. We are trying to locate your strengths in law. So which area of law would you say is your strength? Is your strengths lie?
My strength in law lies in the land law and family division.
Court for land matters. So I think would benefit from you on matters of succession.
Yes.
Let me take you to the Constitution. When you are applying the provisions of the Bill of Rights, and when you are interpreting the Bill of Rights, what would be your duty? I want you to tell us 4 guiding principles that will guide you when you are interpreting the Bill of Rights.
When I'm faced with a matter and I'm interpreting the Bill of Rights, the first thing that I would actually look at is there an infringement? If there is an infringement,
Yes.
the second thing that I would look at is has that infringement affected the individual to the extent that that right has caused him harm and damage? So that's the second thing that I would actually look at. The third one is I would look at the law, I would look at the Constitution and look at the area where that infringement has come from and be able to match all those and be able to actually create a case out of it and be able to move on and deal with that matter at that particular time.
Yes.
Yes.
Now you have found there is a case.
Yes.
So what will guide you in compensating this victim of violation of rights?
The guiding principle there would be the extent of the violation, in the sense that
you have found there is a
yes,
violation.
yes.
So in giving a remedy, what will guide you?
I'll need to check on that, but
You need to check
I'll
on
need
that.
to check on that. Yeah.
Yes, there are 4 broad principles.
Yeah, I know those principles. Only that it's
yes, that's a hot seat.
yes, I think it's a hot seat, my lady.
Yes.
Yes.
Now we can come closer to the area that you are familiar with. That is the law of succession. Can you tell us why are we still having a huge backlog of cases in succession matters that are not, we have the law of succession cap 160, which is very, very clear. But why are matters taking long in courts? And what would you do to clear that backlog of the law of succession matters?
Yeah. Succession matters are quite varied. The aspects within the succession law are actually quite sentimental, and a lot of it actually, when you compare the land law, the ELC cases and succession cases, they run pari passu in the sense that they're almost the same. The main issues in succession law are actually aspects to do with land. The biggest aspect is land. And the main reason why, and this
So
was,
as a judge, how would you deal with that?
As a judge,
so that they move fast, because succession is separate.
Yeah, no, I know. So as a judge, I would actually encourage alternative dispute resolutions in succession matters as much as possible,
Yes.
because these are people who have their own traditional ways and systems of sorting their own issues, given their cultural background. Another thing that I'd actually kept in my mind so that it could be a comment from me to the commission is the time taken also to sort out these succession matters is quite long. Once you have actually prosecuted succession and you have the interim grant, the waiting period of 6 months, personally from a legal point of view, is what actually contributes a lot to the backlogs that are in the courts. If we are able to reduce that 6 months by way of succession practice rules coming out to say, or the law actually being amended to really look at that 6 months and reduce it to the IDR.
Number 2, you will recommend amendment to the law. Number 3.
Number three, I would actually ensure that in my court, I'll give priority at any given time to those matters and allocate a lot of time and ensure that I hear succession matters as a matter of priority.
Thank you.
Yeah.
Justice Majaj.
Yes, thank you very much. I've looked at your sample writings. Basically, they're all submissions, and I must say you write very well.
Thank
you
you.
use authorities very well.
Thank you.
And your train of thought is very clear.
Thank you.
So I'll just ask you one question. In one of the cases, you raised a preliminary objection.
Yes.
On a point of law.
Yes.
The locus classicus on preliminary objections is which case?
There's the Casman case. There's the.
Are you sure? Casman?
No,
Casman?
No, not Casman. There's the something Piscot's case. Mukisa.
Yeah.
Mukisa.
Now tell us about
Mukisa's case.
Tell us about it.
Yes.
What happened? What did the Court of Appeal rule?
In that case, the Court of Appeal.
What was the issue in that case first?
In Mukisa. Sorry, I'm getting mixed up in my mind on a few of those authorities that have actually come in on the Mukisa case. But Mukisa case is a locus classicus on
preliminary objections.
On preliminary objections, and we use it every often because preliminary objections are quite a lot.
So the reason now I'm asking now that you use it very often, can you tell us about the case itself?
I'll need to check on the facts of that case, my lord. Yeah.
Thank you very much.
Thank you.
Thank you. A couple of brief questions, Mr. Korir, Counsel. I can see that you have a long experience after your admission from the law school. You have been in practice for a total of 27 years.
Yes, my lord.
Quite a long period of experience. I'm interested in your LLM thesis. And I'll ask you a question or two based on your LLM thesis. You worked with James Finlay for almost 13 years.
Yes, yes, my lord.
12 years and 11 months.
Yes, yes, my
Quite
lord.
a long stint.
Yes,
After that, you went into private practice.
yes, yes, my lord.
Then when you did your 2017, you did your LLM.
Yes, my lord.
And the topic you chose is quite interesting, and I find it interesting myself. Development and neocolonialism in the small-scale tea sector in Kenya. And I think your experience in working for the tea farms and the tea industry and sector influenced your decision
Sure.
to take up this topic as your thesis. Already, then the title of your LLM thesis is very telling, neo-colonialism. Already there is a picture that there's a message you're sending to us, the readers of this. What is your conclusion? Because in your thesis, you didn't give us the whole thesis. It was cut short. I don't know whether it was internally or you gave us the whole thesis.
My conclusion on my thesis was that the local tea sector needs to be revamped, and the directors in those organizations needs to be well learned, and that they need to be stripped away from the practices that the multinational tea companies do within Kenya.
But the multinational companies own the farms.
Yes, in
like
the sense,
James Finlay.
in the sense that they needed to do a lot of CSR activities within their communities. For once, like James Finlay, it didn't take in green leaf from the tea farmers all these years until the post-election violence of 2007, 2008, when they got convinced that they needed to help the farmers to offload a lot of green leaf into their system so that farmers do not go into losses.
So actually, your thesis concluded the result of the thesis was a critique of their practices.
Yes, of the practices within the KDTA systems and the multinational tea sector.
I don't want to go to the details. One day we'll have the opportunity to read it. But did you do this out of honest interest, or perhaps you are angry with them? Maybe did they terminate you?
No. I did it out of honest.
No, you are no grudge with them.
No. I resigned from Finlay's under VR program, and they didn't want me to relieve because I'd worked well for them for 13 years. Yeah, I didn't have a grudge with them completely.
Thank you.
In fact, I've even retained my current MD for Finlay's as my referee in my CV.
Okay. Yeah. They didn't question you after you wrote the thesis?
No. And I've been a proponent for the small-scale tea sector farmers in Bomet and Kericho.
Okay.
Yeah.
Now, lastly, the Foreign Judgment Reciprocal Enforcement Act, Cap 43. Recently, the tea farmers working under Finlay tea farms went to Scotland, and they got judgment against Finlay Kenya Limited for breach of their rights and award of damages, I believe. And the decree was brought back, and it was sealed and taken to the AG's office for enforcement against Finlay in Kenya. But what do you think of the act? But they didn't succeed because of the provisions of the act. What do you think of that act?
I've been following up that matter also because I had an interest in the sense that the affected employees in that class, the class cases that was filed in the UK, were people whom I also.
No. Regarding the Kenyan workers who got judgment.
Yes, in the UK.
Scotland.
In Scotland,
cannot enforce. They cannot get the fruits of judgment in Kenya.
In Kenya.
Because of a Kenyan act. What is your view?
My view is that I think the constitution also needs to be amended and to take into consideration such issues.
Constitution or the act itself?
The act and the law needs to be relooked so that such cases can actually be admitted here in Kenya and the victims are actually paid. I know the status of those victims. They are lowly people, and their rights actually are lightly infringed in the tea sector. And I think that law needs to be really amended.
Thank you.
And to suit in and fit in into involve quite a good number of hundreds of employees in the tea sector.
Thank you.
Yeah.
All the best.
Yeah, thank you.
Thank you, Chair. Good morning once again, Council.
Morning, Andrew.
What is your understanding of structural interdicts?
I need to check that, my lady.
Okay.
Yeah.
Okay. The
Structural
second
interdicts.
question is that among the cases you'll be handling, and some you'll also be cases on appeal from tax dispute tribunal will come to your desk. What is the burden of proof in tax matters?
The burden of proof lies with the taxpayer.
Mhm.
Yeah, and it is it's always for KRA matters. I've known that the burden of proof is quite high on the taxpayer. You must prove. You must have all the documents. You must have all. At least I've handled at least 2 tax cases.
Okay.
Yeah.
And site 3 of the commissioner's action that can lead to
Come
that's
again?
in line with taxes that can lead to an objection. What actions can a taxpayer object to?
In a tax case,
Yes.
I need to check that one again.
Okay. Thank you and all the best.
Thank you.
Thank you, Chair.
Thank you, Honorable Chair, and Bwana Kipngeno.
Yes, my lady.
Just 1 or 2 questions. Having practiced law for 27 years, that is indeed a very long period. And given your application, it is indeed true that you've been in very many other sectors in the practice of the law that you've undertaken for the 27 years. However, when you become a judge of the High Court, you will also be handling appeals from the Magistrates Court.
Yes, yes, my lady.
And it is important that you're also well versed with what you're supposed to do when it comes to appeals. So imagine you're handling a criminal appeal, and there is a case whereby there is a magistrate who took the evidence of, say, 5 witnesses. That magistrate was transferred. There is an incoming magistrate who now has to take over from the previous magistrate.
Yes.
As a judge, and looking at that record, what is it that you would want to ensure was complied with by the incoming magistrate?
As a judge, I would ensure that at least there is a proper understanding by the new magistrate on the proceedings of the outgoing magistrate.
That is all right.
In the sense that if at the end of the day the incoming magistrate feels that that case was not properly handled by his or her predecessor.
It was properly handled, the proceedings are typed, the incoming magistrate can read those proceedings, they are okay with those proceedings. There is no problem as far as the proceedings are concerned.
I think I'll check that that new magistrate came and closed the matter very well.
What do you mean close the matter very well?
Had it, and if there were remaining witnesses to be called, and the matter would just, actually, that the new magistrate has taken that matter to its logical conclusion.
Is there an obligation that is placed upon the incoming magistrate that is provided by the Criminal Procedure Code?
Yes.
What is that requirement that that magistrate must adhere to?
That the incoming magistrate should be able to ensure that the proceedings as up to the date when he or she is taking over have all complied with all the provisions within the Civil Procedure Code.
After this session, please check section 200 of the CPC.
CPC.
Yes.
Yes.
And see what it says.
Yes. Yeah.
And finally, from me, again, the High Court exercising its appellate jurisdiction, and you are looking at a record where a plea was taken. Or basically, simply put, how is a plea recorded in a criminal matter? You are the judge looking
Yes.
at what the magistrate did.
Plea taking is a technical session that must be handled very well by a magistrate. The plea taking session must be properly recorded.
Yeah.
And-
So I want us to go through the motions. It has to be done very well.
Very well.
I agree with
Yes.
you. But what is it that is done?
When a plea is taken, when the accused is brought before the magistrate, the plea is taken, is given an opportunity to answer, then this is properly recorded. A magistrate also takes a mention date within 2 weeks. The same accused would actually be brought back to come and take a plea again during the time of mention.
Supposing
As-
the accused person has pleaded guilty. During plea taking, the accused person pleads guilty.
When the accused person pleads guilty, the magistrate should not be able to sentence that person straight away. At least he'll actually record it very well that the accused has pleaded guilty, and the motions of actually preparing this accused person to stand trial would have actually been concluded, checking the mental state of the accused, ensuring that the accused has the capacity to be able to take the plea, and ensure that at least the accused is a person who can understand all
That's
that.
very well said.
Yes.
You've read the charge to the accused person has pleaded guilty. What is the next course of action?
The next course of action is the magistrate actually will have that matter mentioned so that the sentencing can actually happen.
Thank you very much. I think we'll leave it at that. I can see that most of your practice has actually maybe been in
civil.
civil.
Civil,
Yeah,
yeah,
but you know,
most
now
of it.
here we will not
I
choose.
know, I know.
We will not pick and choose.
I know, but
Oh.
my lady, at least when I become a judge, at least I work hard and ensure
right.
that my court is.
All right.
there.
All the best.
Thank you.
Thank you, Chair. I have only one general question for you, Council. If you were to conduct a SWOT analysis today of our judicial system, would you pick 2 opportunities that exist and advise us on how we can build on those opportunities? And how do we mitigate on the threats? Just 2 of each.
The opportunities that I see in the judicial system that are available is the stressing use of alternative dispute resolution systems that are in place to reduce the case loads. Number 2, the other opportunity that I see is maybe through the Judicial Service Commission, we can actually do a partnership with the county government and county governments and do a lot of public education across the counties and ensure that people understand their rights and understand why when they come to court, what are the processes and what are the systems that are there so that these backlog issues can actually be shortened. Because there's a laguna, there's a missing link between the public and the courts. And that has informed the low confidence of the populace.
The courts, what is the lacuna?
The lacuna, the understanding of court processes by people who come to court. That is what is missing. So I've been thinking that the courts have an opportunity to tell their story to the public, possibly through the county attorney offices in the counties, so that when people come to court, they are well aware of what they need to do in court. And I've always looked at that as an opportunity that has not been explored towards actually reducing this backlog in the court processes in Kenya. Because if we have a population that really knows their rights and know how to approach the courts, it becomes so easy for them even to sort out their issues within the villages using their traditional systems before they come to court. And I think that's an opportunity that needs to be really looked judicially within this country. And that is what has been missing. Because people come to court expecting a lot of hope. But when they get to court, they are frustrated between the registries and the hearings. And they come to court so many times until some of them die along the way before the matters are closed. And that necessitates coming back to court to seek for substitutions and all that. And even when it gets, when the main person dies, that matter just lapses just like that in the court systems. And they don't come to court because they are not aware of how to do it, especially people who come to court and they are not represented. So I always look at that as an opportunity that we can actually have to reduce this backlog in the court cases. If explanations are done in the villages through the county attorney offices, in the collaborations with JSC and other legal bodies in this country, people would actually find it easy to actually talk amongst themselves and be able to solve the disputes that they have. And even if they file cases, they'll actually understand why an ADR system needs to be put in place so that that matter can be sorted very fast. Yeah. The threats now in the judiciary is the low confidence that people have within the judiciary. And that threats come in with a lot because of, there are so many issues between when a party files a matter in court and when a matter ends. There are so many issues that really affect litigants within the court process. One of them is the corrupt systems that we have in the judiciary, and a lot of a lot of that corruption is usually perpetrated within the registries in the courts. And I thank the Judicial Service Commission and the courts in Kenya because of this employment of the IT system. It's going to reduce the corruption indexes within the judiciary systems very, very much, and sort out
you've said, how will the corruption be reduced?
That
you said corruption exists in the judiciary.
Yes, it's there. I can.
So it's not a perception.
It's not
Indeed,
a perception.
it exists.
I'm a practitioner in Kericho. It happens. Filing a matter, pushing a matter, and ensuring that a matter ends takes a lot of corrupt practices to happen. How do you explain a matter like a succession case? Someone comes to court under certificate of urgency or in January. By March, you already have a grant under certificate of urgency. Whereas the normal succession process takes up to about 10 months before a counsel who genuinely follows his succession matters within the court process have his grant. It's because of someone within the court is able to certify that as urgent. How it runs to the Director General of the government printers, a gazette be given, and a grant is given within 2 months.
So how will you deal with that when you become a judge?
I would actually not allow succession under certificate of urgency. I would decline it completely, because that's part. Imagine in a village where someone has been in court I have a case that has been in court since 2008, and our next villager in the village comes in under certificate of urgency through the guidance of a lawyer. Of course, this thing is perpetuated between ourselves, lawyers, and the registry staff and all the other people in the judiciary. And that those neighbors, this one is telling him, I went to court 2 months, I have my grant. The other one is saying, we've been in that court since 2008. You will not expect confidence to be inspired within that village if that happens. That's why if I became a judge today, I would be very hard. I would not allow any certificate of urgency to be done in the lower court or in my court. I would refuse on succession matters. Okay. Even if the reasons that are being proffered before me are so serious, I would actually tell them to deal with it on the ad litem systems, to deal with it with limited grants as we pursue the succession matter. Succession matters, once a grant comes out in 2 months, as a lawyer, I'll go to court and object it, and it takes another 10 years to end. Because the reasons given by these guys asking for certificate under urgency would always be lies. They would have lied across the system to get the grant, run to the Ministry of Lands using the correct systems. They transfer the parcels of lands, and within that system, the only way the other family members would get to know that a grant was issued is when they are being served with a court order that this land needs to be subdivided by a surveyor. So they wake up and say, when was the succession done? When you go back to the system, you find that succession only took 2 months and the fellow has a grant. That's why I'm saying confidence within the court needs to be enhanced by actually looking at the overall system and really interrogating it and looking at it piece by piece and seeing how it can be done.
Okay,
Yeah.
okay, thank you,
Yes.
thank you.
Yeah.
Yeah, thank you very much. I can see preferred ADR. Are there other methods in which we can help for the public to access justice? We have on record that over 80% of Kenyans actually don't come to our courts. Now, other than you seem to prefer the ADR, are there others
ADR works.
methodologies? Yeah?
ADR works. I'm a proponent of ADR myself.
Uh-huh.
Yeah, ADR really works. And if we can look at better results if this ADR system is also redomesticated down to maybe the county courts. We can go back to the county courts and have these county courts maybe moving from one sub-county to another sub-county to handle these issues on court matters. We can be able to reduce this backlog because 80% of the court matters, I can talk about Kericho. 80% of the court matters in Kericho is land cases and succession matters. Yeah.
Now, when we talk about alternative dispute resolution mechanism, are there other alternative justice systems that can also be looked at? What are they? How many? What else do you do? Would you suggest we adopt to solve the problem of delays?
Maybe we think about we do a case study with the Rwandan village court systems. I don't know. See how it works.
Mm-hmm.
Yeah, but ADR is the best system that can actually work a lot of magic within our courts because it cuts across all sectors. Even some of the the small criminal matters that actually hang around the court for a while can actually be dealt of with some out of court settlement processes that can be put in place.
Yes.
The only big problem is that wherever we have these out of court and ADR processes, we are challenged in our court systems because we don't have a lot of courts do not have the facilities for the ADR systems to take place. The side that you'll find them actually on tents, which do not have chairs, do not have tables, but those are administrative issues within the courts. But I would actually propose as a proponent for ADR myself that this system be given a boost. It be supported in our courts,
yes,
so that this backlog of cases can actually be reduced.
Now, you also mentioned about prevalence of corruption, and you admit that this is an endemic problem, which is not just limited to our staff, that the lawyers also perpetrate it.
Yeah.
What would you do as a lawyer now, or what do you propose within your profession? How do we tackle it? We may know how to tackle or we may have ideas on how to tackle it on our side. How about on the part of the lawyers themselves?
Law society needs to come out very clearly and really talk about it very openly. And we should be able to flag ourselves as lawyers on who is doing that within the court. Because amongst ourselves, we know when you see a file moving very fast, nothing stops you from making conclusions that this file is being propelled by corrupt practices. Yeah, so as Law Society of Kenya needs to put it in its agenda, and it needs to be discussed. It needs to be an open discussion, and we need to do it. This also has been lawyers and their clerks within their offices. Those are the people who perpetuate these fights. And I think if the Law Society comes out very boldly and in the agenda actually talk about this vice, it's going to be reduced marginally. And we are going to see a lot of confidence coming back to the courts. Yeah.
Lastly, again on the corruption question, how comes in Kericho talk of corruption and corruption is at the top? How comes? Because it seems to be a matter that is quite epidemic in that area.
It's common. It's common in Kericho. I don't know why, but at least it's common, it's there. Can confidently say that without any contradiction. Yeah.
Okay.
But it's a vice that we can all handle as a team, Judicial Service, Law Society of Kenya, Court Users Association, and all these other parties involved in the court systems. We can actually sit down and really look at it and say,
Okay,
this is a
thank you.
vice that needs to be stopped. Yeah.
Thank you, Honorable CJ. Mr. Korir, some of the documents that you were requested to submit, there was the declaration of assets, liabilities, and income. I haven't seen that in your submission.
I thought that would actually apply to someone who works, because I'm in private practice. I didn't submit that one. I thought it would not apply to me.
Okay.
Yes.
Do you know why it's important to submit
Yes,
that
I know.
document?
I know.
Why do we ask for it to be submitted? Or why is it important to submit that
It's important
document?
because it talks about the individual actually making the application for a job like this.
Mm-hmm.
Yes, it's a self-declaration form that you tell the commission and you tell any other audience that this is who I am, and these are my assets, these are my liabilities, and all these other things. I did not submit because I thought that that would only be done by people who are actually in employment.
But it's done periodically. Do you know why we do it periodically?
Yes.
Why?
I know. It's done periodically so that at least the users of that form will be able to see the progression of an individual in terms of wealth and liabilities that they have.
Okay.
Yes.
So in your bid, you did not think that because you're considering you for this position, we also need to know where we start you off at.
I'm so sorry. I did not intentionally leave it out. I personally thought that would be done because when I went to Bomet, I actually did it. And when I appeared before the county government public service board, I actually presented that to the county assembly.
But for the JSC, you did not think it was important?
No. It's not that I didn't think that it was. I thought that now that I'm no longer in formal employment, I didn't feel it. But I can still feel it. There's no problem.
Okay.
Yes.
Having been in private practice for over 20 years, I'm sure you have looked at the downsides and the good sides of becoming a judge.
Yes.
Could you please give us two of each that you've been juggling with?
The good side of being a judge, of wanting to be a judge in this country, is to be able to offer my services to the Kenyans and be able to serve this country as a public servant in my capacity as a judge. I would also be able to help. I think I have the skills, I have the competence, I have the integrity to also help the judiciary in actually tackling some of these vices like corruption, backlog cases, and actually going even to the villages to ensure that I use my mechanisms to really sensitize the villagers on how to go about with the court matters. The downsides about this is that as a judge, you are expected to keep a set of life that would naturally change from my practice, my private practice. I can do anything now. I can walk within Kericho town without anything. But I'm very sure as a judge, my level would be enhanced. So I would need to, and I need to really look at my integrity so that even the places that I would go, I would not go as I would usually go very freely. So I think that's the downsides of being a judge. But overall, the advantages and getting...
You've given me one downside. I wanted to.
The downside of being a judge is the perception of the public. Especially if they know that Eric Korir has been a very good person and all of a sudden I've become a judge. And a lot of perception is out there about the judicial officers in terms of how they manage the court cases, how they do their matters in court. Because we have clients who walk to us and they tell you, hey, Korir, I want to give you this matter, but you need to talk to a judge. I've always told them, no, I talk to a judge by appearing before him. I don't go talk to a church from the
So
sidelines.
the area of perception, how have you prepared yourself
I'm well,
that you're going to be getting this backlash?
I'm well prepared about that.
How have you prepared yourself? for
I'm well
that?
prepared. I have a past experience where I walked in, where perception also was there, and I kept myself very clean for the period that I worked for that employer. I was even given tax the names and all that, but I still walked tall and ensured that I did my work as I was required.
Okay.
And at least now within Kericho town and within Bomet town, I'll not look back because I'm very clean. I've never tied anything that belongs to anyone.
Okay.
Yeah.
Thank you, and I wish you the very
Thank you
best.
so much.
Thank you. Now, on corruption in Kericho and these expedited applications and a certificate of urgency under the law of succession.
Yes.
Have you raised that matter at the Court Users Committee?
I currently have two matters that that I just took brief. I was given the other day, two matters, one in Sotik and one in Kericho.
So you need to raise it
I'll do that. I'll
at
raise it. I'll
the
raise
Court
it, my
Users
lord, my lady.
Committee, because my recollection of the law of succession has no provision
Yes.
for certificate
Yes.
of urgency.
Yes.
It has no provision for applications. You just have to file a petition and you go to court and do the substantive matter.
Thank you. Thank you, my lady.
That is the determination
Yes.
of who are to be appointed as the administrators of the estate, and the next stage is the determination of the beneficiaries and
Yes,
the
and distribution.
of the estate. So if you can help us by becoming a champion,
I'll do that. I already filed my objections to the grant.
Yeah.
And I'll actually raise it up with the Court Users Association. I'm
Yes.
very bold about it. I don't shy away.
Yes.
Because with my years of
And
practice,
say you also discussed it with the JSC, and
Yeah,
the JSC recommended the matter be discussed at the Court Users Committee.
I'll do that.
Thank you very much. I think this brings us to the end of the interview. A very interesting interaction with you this morning. We wish you well, and we send you back to Kericho with our greetings.
Thank you.
When we finish the exercise, we will get in touch with you.
Thank you.
But we wish you well.
Thank you so much.
And encourage you to continue doing the right thing and becoming a champion for good practices.
Thank you.
But if you have any question, you can also ask us.
The issues that I had, I've actually discussed it within my answering of the questions. One of them was a possibility of the JSC with other bodies involved of reducing this number of months that one has to wait for the succession matters to be able to end.
Yes.
Number two is that I've been a proponent of ADR.
Yes.
I don't know how best we can actually take these ADR systems into our local villages and local units through the court systems, and be able to really expound on it and have these matters handled within those areas. Because I'm very sure if we took it down there, someone would just say, and I have a case in Kericho, I have a case in Sotiko Bomet, which has been lying there for the last 3-4 years. Why don't I try this ADR? By doing that, we are able to reduce this backlog.
Thank you very much.
Those are the two things that I had. Otherwise, thank you so much for my areas that I was not able to properly articulate. I'm sorry. I have what it takes to be a judge. I request honestly that I be given this opportunity to serve as a judge and to serve as and to work for the Kenyans in this capacity as a judge. Lastly, I take this opportunity to thank everyone for giving me this opportunity to appear before you. It's a privilege, and I will not take it for granted. Thank you so much.
Thank you very much.
Thank you.
Even your views on how we can make the law more effective are taken into account, and even how to scale up our NJS so that we can get to the villages and get people resolve their own disputes. It's within the framework of the judiciary.
Sure.
So thank you very much, and we wish you well.
Thank you.
Yes.